Good afternoon. My name is Alex Boulit, and I will be talking about both of my cases. So my first case for my final exam current events is going to be on FMLA. Okay, it's going to be Hotel de Pancha. The LLC. They own a Home 2 Suites, and that location has federally protected FMLA leave because they qualify for everything. They have more than 50 employees. Um, and they retaliate against an employee by firing them after the employee filed for FMLA leave. The hotel was found guilty and was ordered to pay back $7,105 and back wages to the employee. This case ties in with a lot of things from the textbook. So it ties in with obviously FMLA, the qualifications for a hotel FMLA, like they were qualified, and then retaliation. They denied their FMLA claim, and then they denied them, and then they fired them after that, which is obviously retaliation. And it's shown that they were wrongfully terminated and that they had to give back pay in the FMLA money that they owed. So this case, it's in a message to the hospitality industry in terms of financial and legal consequences that other hotels would have to endure if they did something similar. FMLA claims are very serious, and it's not something that should be taken lightly, or that hotels should just deny without any evidence for the reason for the denial. This most likely will cause other hospitality employers to review and update their FMLA policies and training for managers to ensure that they have compliance. My second case has to do with independent contractor issues. So Amazon Flex, it's the independent Amazon drivers that use their own vehicles to deliver Amazon packages. They basically use an app in which they go to the Amazon warehouse and they pick up packages, and they can choose their routes and what they want to drop off. It's a similar model to Uber Eats and DoorDash, in which the driver picks up a McDonald's order and then takes it to their house. They don't actually work for McDonald's. And so because of this, Amazon classified these employees as independent contractors. However, it was proven that they were misclassified and that they weren't actually independent contractors. So specifically, the case I'm referring to happened in Wisconsin. The Supreme Court upheld a suit that said Amazon Flex drivers should be considered employees and are eligible for unemployment. So Stephanie, president of the Wisconsin AFL-CIO, held the court's action, calling it a win for working people. Far too often, especially in the emerging gig economy, big and powerful companies like Amazon use the misqualification of employees as independent contractors to deny working people essential workplace rights like minimum wages, overtime pay, and employment insurance. The court found that Amazon had misclassified Amazon Flex drivers as independent contractors and found that they owed $205,000 in unemployment insurance premiums. So yeah, basically Amazon should have been more careful, and they should have, really looked at how they classify these employees. They are not independent contractors. The court found that they're actually employees of Amazon, so they owed them unemployment for when they got laid off, and just like basic employment benefits that employees are owed. Yeah, my name is Alex, and thank you.